Ladies and gentlemen, we are back again in this second part, in this interesting discussion we have with the UK legal advisor to the United Nations, Chanaka Wickremasinghe. And along these lines, we are talking about the UN as an organization, about the different organs of the UN, about the Security Council, the General Assembly, and Chanaka, with your permission, I would like in this second part to open the discussion with the role that states, especially small states, can play or cannot play in the realms of the particular organization. If your first comment about small states, of course, you represent a big state, a big major player in the international arena, the United Kingdom, but do you think from your experience in the organization that also small states can have a voice in the realms of the UN?
Definitely. I think the idea of particularly the General Assembly is that every state has an equal voice in the General Assembly, and so even a very small state can have its voice heard there. Obviously, there is a sort of political reality that if a small state is going to be heard, it will need to do a lot of diplomatic work to ensure that it has sufficient support behind any initiative that it's running. But that's also true of larger states as well, that if the UK wanted to run something in the General Assembly, we would have to do a lot of legal legwork as well. So very good examples of small states having major influence recently would be, first of all, the Vanuatu, which I hope they wouldn't mind me calling them a small state. They're a small island developing state in the Pacific, and the Pacific island states cohere very well. They have they work together closely, and they quite often run initiatives or at least concert when they're facing particular questions at the UN.
Chanaka, just to put a semicolon here, because I'm tempted to ask you, do you think that this is maybe an example for the UK and the common law countries to also work together in major international threats and challenges? In the Pacific Islands, because maybe of a common culture, a common kind of threats, dangers, challenges, they can unite. Maybe also the UK, through the Commonwealth, also the leader of the Commonwealth, can also take a step and unite the common law world.
I think there is a really important role for the Commonwealth to play. And in terms of the common law, I think indeed there is a role that could be developed further in terms of more. I mean, there is already a certain amount of discussion amongst Commonwealth leaders at the Commonwealth Law Conference and so on, where senior legal leaders from the Commonwealth countries get together to discuss issues. But I would sort of very much welcome to see that extended to New York. One area I think that is perhaps a little underdeveloped in our practice is the sort of law and development aspects, that the sharing a sort of legal family, we could assist each other in the process of development and the development of stable societies under the rule of law, in line with the Sustainable Development Goals, SDG 16, I think is very much along those lines. And I would see a role for common law countries to get together and think about those sorts of issues together, certainly. I don't say that it has to be a UK leadership role at all. I think it's very much more collective responsibility than that.
When it comes to the United States and the history of the United States, we know also that the Englishmen were among the first who went to the particular area. What do you think of the relationship now between the UK and the US? Of course, it's a very friendly relationship, a very fertile relationship. But when it comes, for example, to this understanding in common matters, in the past it was very acute, especially with the Second Iraq War. Do you think that the US continues to be one of the strategic partners when it comes to the UN and the role of the United Kingdom there?
Yes, I think very much so. We work closely with our US colleagues here. We often share a worldview. We often share very close legal view, a close sort of coincidence of legal views. We we have tended to go through many of the same experiences together, which has kind of shaped our view of the law. And so I would say that we had a particularly close relationship with the US indeed.
Which is very important
Including on
also,
legal
because after
matters.
Brexit also, the US must be and can be also a partner, a major commercial partner, a major also strategic partner, because the Atlantic Ocean divides the two countries, but also the distance is not so great as maybe with other parts of the world and the United Kingdom. But to return a bit to the small states, with your permission,
Yeah,
and to ask
yeah.
in essence, we spoke how Vanuatu, for example, brought forth consensus regarding the climate change. We have in the past, if I'm not wrong, the case of Israel and the development of the desert in one of the committees. The question is whether you think that this consensus and the ability of the small states to actually put forth things in international law is actually tied to the fact that these issues, these subjects, are subjects that refer to consensus, meaning everybody, or almost every state, thinks and believes now that climate change has to be tackled, or the development of the desert is a goal that speaks to the hearts of many, or if not all states. Do you think that's a reason why we see that small states are able to proceed with the formation of international law?
Um, I think that's probably right, that they are able to take issues that are of a more general interest and pursue them with kind of very skillful diplomacy that both your examples have shown in terms of building a coalition around an idea and eventually it emerging as a consensual project for the whole of the assembly. So I do think that there is a real role for them. And if I could just add another rather interesting example of a small state having great influence on an issue. Last year, Liechtenstein moved a resolution in the General Assembly that where a Security Council permanent member uses its veto in the Security Council, it should be invited to the General Assembly to explain the use of its veto. Now, this has happened twice since that resolution happened, and on both occasions, the relevant permanent members went to the General Assembly and explained their use of the veto. So that's quite an interesting development in terms of
it is an interesting development. It keeps the balance also between the permanent members which want, of course, to keep their permanent seats, and also the ability to hold them also into a kind of an accountant procedure. With this in mind, I want to take you also to the other side of the Atlantic. We said how the Atlantic Ocean actually divides between the UK and the US, and divides also between New York and another major city here in Europe, Strasbourg, where in essence we have the European Court of Human Rights and the Council of Europe. You have also experience from there. How is it to be a legal advisor? What are the differences or similarities to be a legal advisor stationed in the Council of Europe vis-a-vis stationed in the UN?
Yes, well, again, a fascinating question. I wasn't actually posted in Strasbourg, but I was the government's agent for their
Yeah, this is
cases
what I meant,
before the
yes.
European Court of Human Rights. And I also represented the UK on the sort of main intergovernmental committee that oversees the sort of general health and well-being of the European Convention on Human Rights. There's a particular committee of experts that deal with that, and what I find the kind of core difference is that obviously with the Council of Europe uh, there is a smaller number of states. There's kind of 45 states as opposed to nearly 200 states in the UN, and there is very much a sharing of values around the European Convention on Human Rights, and in general, the European Convention on Human Rights has been a great success. It has large numbers of cases. It has a good compliance rate with its judgments. And so it really has kind of fostered a close level of agreement on some important issues that are actually quite intrusive into the national legal system as well. So European states have accepted the international interest in international supervision of some kind of core legal concepts, whereas the UN system is still quite a long way from that in terms of human rights. Much of the human rights work, I think, is now is obviously dealt with in Geneva, where there are huge number of the treaty bodies and other procedures, and that has become the sort of area of that's become the place of real specialization in human rights. The discussion in New York is a more political one about the more political direction of human rights and also looking at particular country situations and so on. In the Council of Europe, we have kind of very focused development of European Court of Human Rights and its case law, which is sort of gets which sort of is able to exercise a degree of supervision that is not enjoyed by any of the UN bodies yet, whereas the UN one has a sort of broad coverage of the world, obviously, but a sort of multiplicity within that of different systems, different treaties having different treaty members, different treaty bodies having different say in issues, and so I think that the way human rights is generally dealt with in the UN is quite different to
That's
Strasbourg.
a very sensitive issue, and it's
Yes.
very interesting that you enter this discussion, because we can speak about the UN Human Rights Council, and we know that Kofi Annan already from 1998 and other people have diagnosed the feeble character of the UN Human Rights Commission, and they instituted the UN Human Rights Council that still, though, is a recipient of complaints of politicization. And you stressed in the beginning of this interview, in the first part that our viewers can see in the separate video that is available here, you stressed the role of states as formation leaders of international law. But when it comes to human rights and the UN Human Rights Council, does it work? And if it does not work, maybe here international law should adopt the UN Human Rights Committee paradigm, meaning to have experts, maybe representatives of states, but experts, independent experts, like the case of the ICJ or the International Court of Justice, because we see that when states take the first step in trying to protect and render justice regarding human rights, maybe they don't always do the best job.
Yes, it's a fair point, and the development of the Human Rights Council from the previous commission and subcommission, I think, is definitely reflects dissatisfaction with the way the commission and subcommission worked. The Human Rights Council still has its detractors, I fear, but there are some useful processes within it. There's the process of universal periodic review. There are the kind of special rapporteurs that are assigned to themes or even to country situations. In these ways, some objective sort of establishment of the facts, as it were, is sought. And so I think, whilst the Human Rights Council is not free completely from politicization, I do see that it is evolution from the way the commission and subcommission worked previously.
Indeed, and we're speaking about evolutions. Evolutions, though, as you said before, are being stirred mostly, it seems, in Europe and the Council of Europe. And I'm speaking now about the whole reformation of the European Court of Human Rights, the relevant protocols. We have in 1998 the whole reformation of admissibility of the cases. But most importantly, we have the court, the European Court of Human Rights, coining already from the 60s, as we know, the issue of the margin of appreciation, this particular concept that came to grant some flexibility to the court. So the question is, also from your experience as a diplomat, having to relate to the European Court of Human Rights and now in the UN, and having maybe to deal through the General Assembly, which asks for advisory opinions vis-à-vis the International Court of Justice, the ICJ, whether do you think that the margin of appreciation is a concept that should be exported from the European Court of Justice of Human Rights also to other international courts?
It's a very interesting question, and I'm not sure I'm best placed to answer it. I do remember my
also
first
the
teacher of
political
international.
facets of it, maybe the flexibility in the compliance of the judgments,
Sure.
etc.
I was just going to say, I remember my first teacher of international law, Judge Rosalind Higgins. She told us, she was a member of the Human Rights Committee at the time, and she told us that it was her absolute determined wish to ensure that the margin of appreciation never made it to the Human Rights Committee, and I think that's been upheld since. I think the margin of appreciation works in Strasbourg, certainly, where, as I say, that there is a sort of broad coalescence of views, but exactly how you get there is, what solutions different states adopt can differ, and also the sort of level of supervision that as I say, that the European Court exercises over national jurisdictions is that much deeper, and so perhaps I mean, I would think that the margin of appreciation is a suitable tool in those situations. In the UN, where things are perhaps at an earlier stage of development, as it were, or at least not so developed in terms of the depth of supervision internationally, perhaps there's more of a case for trying to establish the kind of basic principles and not worry so much about the details of the margin of appreciation.
So you don't think that there's a kind of an argument that all the more so when it comes to diverse opinions, like in the UN, we should employ the margin of appreciation? Maybe you're afraid maybe that the margin of appreciation will dismantle, in essence, a diversified international order.
I think there is it's a difficult doctrine to supervise, I would think. I mean, where you have a court supervising it, like the ECHR, then it works well. If it was left purely to the political processes of the General Assembly or the more politicized aspects of the Human Rights Council, then I think it would be very difficult to establish any sort of firm basis for the rights we're talking about.
Which is very interesting, what you say right now. I will return a bit to the international human rights accountability issues. I know that your PhD thesis at the London School of Economics is about the issue of immunities. And my question would be, how do you think, also from an international point of view, that immunities block, and still, because you wrote the thesis some years ago, if you still believe that immunities block the evolution of international law and also the political development in the United Nations? And I refer, for example, to the al-Bashir case years ago regarding the International Criminal Court. Now we have other leaders that again are before the International Criminal Court, but not only on international criminal law level. What do you think about immunities in international law? Should we get rid of them or to mitigate them, and to what extent?
So I don't think I've ever thought that immunities were a block to international law. I always thought that they were very much a part of international law, and they were the way in which a system that allocates jurisdiction on a national basis primarily can interlink with each other. So one state doesn't use its jurisdictional powers in a way that affects the sort of very essence of the activities of another state within its own domain. And so I really wouldn't see that immunities are a block on the development of international law, and I don't think my thesis said that either. My thesis was really addressed to international.
To be clear also for the viewers, I didn't say anything else. I left it open for you to respond.
Of course, and my thesis really focused on the privileges and immunities of international organisations, as you mentioned, whereas the subject of immunities obviously goes much wider than just organisations. I mean, if a state or an international actor is to be given immunity, that shouldn't necessarily mean that they're free of all accountability. I think in principle, the exercise of all public power should be accountable. It just depends the forum in which you immunity is about the forum in which you hold public power accountable.
And so, what you mentioned is very important in the sense that so far we usually tend to think accountability as attached to international criminal law. But as you say, or you imply right now, there are all other forms of law and state accountability or individual accountability that can actually be brought into the surface. For example, we have tort law accountability. And along these lines, I would like to ask you, because I know you have spent also a relevant chapter on this, and we know that some years ago, especially, the phenomenon was very acute, about UN officials being revealed that they were involved in atrocities in the countries where they served their duty as peacemakers. How do you think that the international community has tackled enough the particular problem, or more should be done in this perspective?
It's a very interesting question. I'm not aware that UN officials have committed atrocities in the sort of usual sense of crime against humanity or war crimes, but there have been concerns about, for example, crimes of sexual exploitation and abuse by peacekeepers or other UN officials, and those are obviously hugely serious crimes. There is ongoing work in the Sixth Committee. There has been for a number of years to try and establish a better system of accountability there, to try and press states to take national measures in relation to their own troops, or where necessary. I believe that the UN is likely to waive immunity for its own officials to face criminal proceedings in such cases. So it is a work in progress, but it's an area that is still somewhat underdeveloped, I think. The UN does have an obligation under its Privileges and Immunities Treaty to provide means of account for private law type actions where they assert their immunity. So, for example, in relation to tort cases, they ought to provide some other mechanism for individuals to seek reparation.
So do you think that when it comes to reparations, in essence, because now I have in my mind also the jus post bellum, and the whole also relevant chapter that is being developed in international law, because so far we spoke about jus in bello, the laws of war. For the last few years, we speak about, as you say now, compensation, reparations also after the end of hostilities. So do you think that this transitional justice facet that you touch upon now is going to be more predominant also in the realms of the UN accountability?
That's a very interesting question. I would sort of probably need to think some more about it, and I don't really have the great expertise on it. But where, for example, the UN has been involved in the administration of territory in, for example, Kosovo, or there have been other transitional arrangements in other states as well. Yes,
more or less in Oceania, yeah.
There, I think there is some there is a strong sort of moral case for the UN to hold itself to some form of accountability process. It may not be civil litigation as we know it in a national system, but there ought to be some means of recompense whereby complainants can have their complaints heard and account to be held where due.
And Chanaka, for the end, a kind of more not personal question, but a question that pertains to the United Kingdom, in order for our viewers to understand the importance also and the role the United Kingdom plays in the United Nations. Can you tell us some of the agenda that can be revealed, of course? What are the initiatives the United Kingdom wants now to push forward in the realms of the United Nations? What are the priorities of the mission in the United Nations right now, if we can say to the public?
Right now, the United Kingdom is very focused on its support for the government of Ukraine in its resistance to the invasion of its territory by Russia, and that does dominate a lot of our work here. There are frequent meetings in the Security Council where Ukraine is discussed. There are numerous General Assembly resolutions that you'll have seen that have been run in the past just over a year now, where the General Assembly, as you mentioned earlier, has kind of stepped in under the Uniting for Peace resolution. In addition, this is really an important year for development issues. There is the halfway stage of the Sustainable Development Goals is reached this year. Those goals are behind schedule, as it were, and there is a conference later this year at which we will be seeking to unite action to move those forward.
Climate has about fields of international law. You mentioned before the biodiversity convention. We're talking about environmental issues that are in the high priority of the agenda. What kind of issues should we see being promoted?
So we obviously had our presidency of the Conference of the Parties of the framework on climate change, framework convention on climate change, a couple of years ago, and we're still sort of hoping that to see the sort of agenda we had there played out in the course of the next year's COP that will be held under the UAE presidency, and we'll be working towards that. In terms of us as legal advisors, we'll obviously be following the Vanuatu advisory opinion closely, and I'm not sure if we've made a decision yet to make our submissions to the court on that issue, but I would be surprised if we didn't.
Chanaka, thank you very much for this interesting conversation. I hope and I'm sure that our viewers must have enjoyed it very much. Ladies and gentlemen, this was another episode of the BUL Emerging Law Voices series, directly in connection with New York and the mission of the United Kingdom to the United Nations. With this, we thank very much the legal advisor of the UK mission to the United Nations. Thank you, Chanaka, indeed, for a very fruitful discussion. And ladies and gentlemen, we look forward to seeing you in the next episode of the BUL Emerging Law Voices series. I'm Dr. Solon Solomon, lecturer at Brunel University London School of Law and host of the particular series. With this, I bid you farewell and we renew our meeting for the next time. Thank you very much for watching.